This is Michael Popok with a Legal AF breaking news alert. Judge Cannon has now ruled against the prosecution, and she's found a way to both deny the motion for a gag order to stop Donald Trump from claiming that the FBI was involved with a plot to attempt to assassinate him when they were executing the Mar-a-Lago search warrant, which is complete BS and fraudulently made and defamatorily made, does not constitute campaign speech. Yet Donald Trump continues to dox and put a target on the back of the FBI and the Department of Justice and try to get away with it. Special prosecutor, special counsel Jack Smith and his team filed a motion on Friday over the long weekend to have the court address the issue of whether he should be gagged and stopped from claiming that he was the victim of an attempted assassination by the Department of Justice, which of course undermines the criminal justice system, influences future jurors, and puts a target on the back of imminent danger against the FBI and the Department of Justice. You would think the judge would be interested in all of that. And the first filing that we got from Donald Trump just yesterday that we reported on here on the MeidasTouch network was not going to the substance about the assassination allegation and the fraud of it, but instead argued that under the local rules that the Department of Justice did not give Donald Trump a meaningful opportunity for conferral, meaning they didn't have a meet and confer, a conversation before the filing of the motion, which they are right, is required under most circumstances before a motion is filed. But I would beg to differ. The Department of Justice did provide notice to Donald Trump's team before they filed, provided them with a copy of the motion, gave them time to get on a phone call with them and have the conversation, and they were met with resistance on Friday. They were told, we'll talk to you on Monday. We're in the middle of another trial, the trial in New York, and we're trying to put together our closing argument. We don't have time for a 10-minute phone call. And the Department of Justice said, we can't wait till Monday. You know, they have an obligation to give them advance notice and to have a meet and confer, but the other side has to meet them in the middle. And if they refuse to effectively meet and confer, which is what Donald Trump's lawyers have done, they shouldn't benefit from it, but not according to Judge Aileen Cannon, who in a paperless order blamed again on the heels of a hearing in which she told the Department of Justice to calm down and to stop making arguments in her court effectively, which just happened last week during motion to dismiss practice. Now she's taking them a task again, beating them with both ends of the stick, the prosecution. Here's what she said in her paperless order. I had to take a photocopy of it. I had to take a screenshot of it to read it to you. And she totally went with the argument Donald Trump raised, which was not a substantive argument about his speech or campaign speech, even though they threw that in there. It was about, we didn't have time to meet and confer because we're working on other things, and Monday wasn't good enough for the government, or some whining snowflake attack like that. And then trying to get two bites at the apple, attacking the prosecutors, saying that they are underhanded and they are unscrupulous, and the judge knows it. And this is campaign speech by the leading candidate for president. And by the way, we didn't get a chance to meet and confer about this before it was filed. This procedural technical issue, and the judge went with it. The judge bought it, hook, line, and sinker. Here's what she said. Paperless order denying without prejudice for lack of meaningful conferral, meaning talking before the motion is filed. Defendant Trump's procedural opposition, the court finds that the special counsel's pro forma conferral, in quotes, to be wholly lacking in substance and professional courtesy. It should go without saying that meaningful conferral is not a perfunctory exercise. Sufficient time needs to be afforded to permit reasonable evaluation of the requested relief by opposing counsel and allow for adequate follow-up discussion as necessary before the underlying motion is filed. This is so even when a party, quote, assumes the opposing party will oppose the proposed motion. Because the filing of the special counsel's motion did not adhere to these basic requirements, Judge Cannon went on, it is due to be denied without prejudice. Any future non-emergency motion, hold that thought, I'll tell you about the emergency motion part in a minute, brought in this case, whether on the topic of release conditions or anything else, shall not be filed absent meaningful, timely, and professional conferral under Local Rule 88.9. Moreover, all certificates of conference going forward shall appear in a separate section at the end of the motion, specify the exact timing, method, and substance of the conferral, and include, if requested by opposing counsel, no more than 200 words verbatim from the opposing side on the subject of conferral, again in objective terms. Failure to comply with these requirements may result in sanctions. In light of this order, the court determines to deny without prejudice Donald Trump's motion to strike and for sanctions 583. That's interesting. She denies the motion to strike and for sanctions because she doesn't think that was meaningfully conferred upon. And she also denies, apparently, the special counsel's motion to modify conditions of release. So it's a little bit of a pox upon both your houses. Trump, you filed a motion for sanctions saying they didn't meaningfully confer, and you want sanctions, but you didn't meaningfully have a conversation with the prosecution either. And prosecution, you didn't have a meaningful conferral about your motion for a gag order. So both of them are denied. Get back to talking. I mean, that's the best way to read it. And again, Aileen Cannon finds a way not to make a decision that can be appealed to the 11th Circuit Court of Appeals, which seems to be her ultimate goal. I think she gets up in the morning and says, how can I still get paid as a federal judge and not really do my job and not worry about my bosses reversing me on appeal the way they did twice before this case started? Now, look, the prosecution has been on their back foot with Judge Cannon almost from the beginning, whether it's Jay Bratt or any of the other lawyers that are in there. She does not like the prosecution team. She acts out against the prosecution team. She tells the prosecution team to calm down and to relax and everything else when they're bringing up major matters and they're getting frustrated by this judge. And this constant frustration is boiling over in the courtroom. And when we get paperless orders like this, sure, the reporting can be both motions were denied. But I think the better way to read this is the judge once again takes the bait by Donald Trump and uses the procedural technicality of lack of conferral, conference before motions are filed, to deny without prejudice. Now, let me explain emergency and denying without prejudice before I leave this hot take. I had questioned on our Legal AF this past Saturday why, if the prosecution was claiming that the FBI was in imminent danger because Donald Trump claimed that they were at the heart of an assassination attempt against him and violent rhetoric like that, why they didn't frame it as an emergency application. And that came up in both the filing by Donald Trump, which was, what's the emergency? They didn't frame it as an emergency. Why couldn't they give us till Monday off of Friday, off for a long weekend to confer? And I think that was a tactical error by the Justice Department, where I'm going to call it the way I see it, no smoke or sunshine. They should have framed it as an emergency application requiring a faster briefing schedule. I would have done that with a motion to shorten the time for the briefing schedule. So it's not 10 days or so or whatever the time limit is. It's shorter, maybe 5 days. And I would have then given the reason why the conferral didn't happen or didn't happen meaningfully. That's one thing I would have done. The new world order that the judge has just set forward is now going to require that if you have a meet and confer, you have to include a paragraph from the other side about why they didn't meet and confer. They had a paragraph, Donald Trump, in his papers. Let me read it to you. This is on page 4 of their filing. They wanted this included. At 5:30 p.m. on Friday evening, the special counsel informed us that they were seeking to modify President Trump's bail conditions based on an as yet unidentified statements purportedly made by President Trump on Truth Social and in fundraising emails. Let's stop right there. He made the statements. We've seen them about the attempted assassination and the use of force authorized by Joe Biden to take him and his family out at Mar-a-Lago, which is a lie. All right, but I digress. Let me continue with what they wanted to have included to the judge. They indicated that they were filing the motion tonight without informing us of the statements that they claim give rise to the relief sought and without allowing defense to respond as required under the local rules. Defense counsel has had no opportunity to confer, nor have we had an opportunity to confer with our client about the requested relief. Defense counsel indicated its availability on Monday, a holiday. Special counsel refused this good faith effort. This is a blatant violation. We want to meet and confer. That's what they wanted included. And now, by Judge Cannon's new paperless order, all future motions have to include a paragraph like that from the other side advocating their position. Ridiculous. Now, in terms of no prejudice, that means you can refile. If it's with prejudice, you can't refile. But if a motion is denied without prejudice, even for these procedural reasons, both sides, Trump's side on their motion for sanctions and the DOJ on their motion for gag order, the substance of this issue, has to now go through a elaborate, policed, dictated meet and confer process that she just created out of whole cloth and has imposed on the parties in this case. So now, I'm sure they're now going to write an email to a set of lawyers for Donald Trump that are now in the middle of their closing argument in New York and say, we need to meet and confer. And the Trump's lawyers are going to say, we're busy right now. We're up in New York with another criminal trial. We'll get back to you when the jury starts deliberating, maybe on Wednesday or Thursday. The judge is going to be fine with that. Or they're going to restyle this as an emergency, which is going to be hard given they already filed it, the government, on Friday as a non-emergency. But they may try to retool it as an emergency and ask for shortened time in briefing. But you can see the writing on the wall with this judge. She's not going to buy the emergency, and she's not going to shorten the briefing schedule to allow this issue to be resolved quickly. She hasn't even set the trial. She doesn't think this is an emergency at all. So unless they get an affidavit that says people are getting doxxed and are really at risk of imminent danger or death, she's not going to move any quicker. So here's how it's going to play out. They're going to do this meet and confer on both motions, Trump's motion for sanctions for the lack of meet and confer, and the meet and confer on the substantive issue, which is the gag order on Donald Trump to stop telling people that he was the victim of an attempted assassination by Joe Biden and the Department of Justice and the FBI. They're going to have that maybe Wednesday or Thursday. Then they're going to... the results of it are going to have to be, here's what happened during the meet and confer paragraph is now going to be included in the refiled motion by the Department of Justice. The judge is already rolling her eyes over this motion. Not a good place to be. The other side is going to file their motion after their meet and confer. The judge is going to have competing motions. It's going to be briefed over the next 10 or 15 days, sometime towards the end of June, July, August. You know this judge. She's going to hold an oral argument or hearing. And then Donald Trump, in the meantime, gets what he wanted, which is to accuse the president of the United States of authorizing an assassination attempt against him. So he can say that on the debate stage, and he can say it to his followers as he's raising money. And so he's won because of Cannon, and there's nothing to appeal, right? There's nothing to appeal because she hasn't ruled. And this paperless order, you need to meet and confer, is not going to be able to get to the 11th Circuit in time to be ruled upon. So then we're going to get a ruling by her one way or the other, end of June, maybe July, and then they got to take an appeal up to the 11th Circuit. And now, tick tock, we're up against the November election. Exactly what Judge Cannon wanted. She's obviously decided among all the federal judges that she's the one that's going to bend over backwards to help this defendant in a way that no other federal judge should or could do. That's what we're watching. That's why we got to do this reporting. I mean, I was just about to do my own sort of analysis of Trump's motion that he filed, right? When we get the breaking news that she doesn't want briefing on any of this, especially she doesn't want to hear from the prosecution at all. So now they're going to have to go through that timeline that I just went through, and then we can report on the new filing by the Department of Justice, which is now going to have to include affidavits, including all of the social media posts and all the fundraising emails that Donald Trump used inappropriately, claiming that Joe Biden is in a conspiracy to assassinate his opponent. And we'll have to report on that instead. So I'm going to continue to report exactly what's happening in Mar-a-Lago, in all the Trump matters, in civil rights cases, in constitutional law cases. And I do it one place right here on the MeidasTouch Network and on Legal AF. Right. Now you know why we call the podcast that. And we named it 4 years ago. We anticipated this kind of shenanigans among some of the judges. We do it on Wednesdays and Saturdays at 8 p.m. Eastern time right here on the MeidasTouch YouTube channel, and then on all major podcast platforms. You can pull up the same show. I'm Michael Popok. If you like what I'm doing, leave me a thumbs up and a comment. It helps with the algorithm. And you can follow me on all things social media at MS Popok. And on our YouTube for MeidasTouch, slide over to contributors and playlist. Look for Michael Popok. You'll find my entire body of work there. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.